Maybe. Yeah. Okay, great. All right, good morning. This is Thursday, May 8th, and this is Natural Resources and Energy. And we are doing again a bit of a preview of a topic that we anticipate may come to this room, which is the appeals section of H 479. I know Senate Economic Development is still discussing it, but we want to be prepared if it comes here. So we're gonna
Latest stuff on that.
yes, oh gosh, it's a big amount. We've just got one
Can we got here?
part of it.
Okay, 479. Okay.
Yeah, so to take us off of this, we have Judge Zone with us to self provision. Welcome.
Good morning, Tom Zone, Chief Superior Judge. Pleasure to be here. If what we were just handed is draft 4.1 from 10:30 a.m. yesterday, that is the one I will use. Is that it?
Yep.
Okay.
Yep.
So I want to be very clear. The decisions as to the matters we'll talk about today are policy decisions for the legislature. You will decide what the appeals look like, who gets to, the person's task, however you decide that, we will implement. And we will do it in a timely fashion that provides due process to the parties and applies the facts to the law that the legislature has. And so but what I think is important is that if there are expectations or impacts, that you should be aware of them. And so I think it's helpful if I just talk about some of the impacts of this bill on what would happen. So if you look at, for instance, on page 31, what happens here is that there's a change in person aggrieved in Title 10. What happened, how this impacts the municipal zoning appeals is that in section Title 24, section 4465, there's a definition of interested person. An interested person is defined in several ways, one of which is a person, this is on subsection 3 of 4465, it says a person owning or occupying property in the immediate neighborhood of a property that is the subject of any decision or act taken under this chapter, who can demonstrate a physical or environmental impact on the person's interest on the criteria that's there. There's also a subsection for interested person that allows 20 people to get together and file. The change on page 31 is tied into what I just read to you, because what happens is the amendment gets rid of that for the zoning appeals. And so instead of those criteria, person owning or occupying, having in the immediate neighborhood, and having a physical or environmental impact, instead, what the new statute would provide is that a person aggrieved is that standard. And it says a person aggrieved means a person who alleges an injury to a particularized interest protected by the provisions of law. And it talks about those provisions of law. And then what it does in the last sentence, it says for purposes of appeals pursuant to 24 VSA chapter 117, injury allegedly shall be to a particularized interest protected by 24 VSA 4302. Typo on line 7 with allegedly, I think it should be alleged. But beyond that, what this bill would do is remove those, if you will, restrictions of property in the immediate owner occupied property in the immediate neighborhood. Remove the physical or economic or environmental. And instead what this says is what we mean is in the legislature, the particularized interest has to be protected by 24 VSA 4302. Section 4302 is under the general, it says purpose and goals for the general provisions of municipal and regional planning and development. The reference subsection C, says, in addition to this chapter shall be used to further the following specific goals. And so what this last line does, it refers to interests that are protected. Yet the statute it refers to does not set forth protections, but rather it sets forth goals. And so those goals, if you look at them, to plan, there's a lot of them.
Are they in the bill?
They are not in the bill. You have to actually go to the statute to reference them.
Okay.
To plan development so as to maintain the historic settlement pattern of compact village and urban centers separated by rural countryside. Number two, to provide strong and diverse economy that provides satisfying and rewarding job opportunities and that maintains higher environmental standards. And to expand economic opportunities in areas with high unemployment or low per capita incomes. Three, to broaden access to educational and vocational training opportunities sufficient to ensure the full realization of the abilities of all Vermonters. Four, to provide for safe, convenient, economic, and energy efficient transportation systems that respect the natural environment and public transit options from passenger pedestrians and bicyclists. And it goes on to final one is number 15. Many of them have subsections. I point that out because there's a lot there. And if you read them, they're very broad. And so what this does is it takes that standard that says you have to own property in the immediate neighborhood. You have to have a physical or environmental impact. And what it says is you have to allege instead, you have to allege a particularized interest, injury. And it has to be a particularized interest protected by those 15 things that are goals. And if you're saying to yourself, boy, that seems like it might be quite broad. It is. And I point that out because if this passes as a policy, and that's your prerogative, there's going to be litigation on what this really means.
Yeah.
We are going to have to define these terms in the courts. We're going to have to set the parameters. And right now, you have 2 decades, let's say there was a big shift back in 2004 under the Douglas administration when there was, it went from boards to the environmental division for a lot of appeals. And you have, based on that section 3 that I mentioned about the immediate neighborhood, there's case law on that. That case law has been developed over the years. The attorneys, the litigants, people understand what that is. The courts, we understand what that case law is. It provides guidance for the parties. That didn't just happen overnight, that happens over time. And that is what happens is the legislature, when you enact a new statute, if the policy goes in a new direction, that's what we do. The courts decide those cases and it builds the case law, the body of law to define the parameters. That's okay, we do that. We show up Monday through Friday, work weekends, work nights to make sure we do that. But the legislature should understand that if that occurs, there's going to be a number of individuals who might not have a property in the immediate neighborhood, and they might not be alleging a physical or environmental harm. They might live across town, and they might be alleging economic harm or some other harm, injury that they're alleging based on these 15 things that are in this quite broad. And the court's going to have to figure it out. That's what we do. But if there's an expectation that this is going to somehow come in and just be self-executing and everybody's going to know what it means and here we are, and it's not going to take time, I would suggest that view needs to be revisited.
Go ahead.
So complete ignorance, so we haven't seen this bill yet, right?
We have talked
We got it
about
from, we
this.
talked about it, but
Yes.
I just figured out what you're talking about. You're talking about maybe person or an Act 250 complaint.
Municipal zoning abuse.
Okay, so, all right, so I'm looking through the bill and figure out where we are. And
We're on page 31 is where I was at. And so,
okay,
and so I point this out because there's nothing wrong with the courts having to develop bodies of case law to provide guidance and parameters. We do that. But if there's an expectation that this bill is suddenly going to shrink the pool of people who can seek standing, I don't think that's what you're going to see as a result. It would be expected that if you broaden the scope and remove the restrictions, then more people are going to seek to have standing. One of the things that's important to recognize is that when you look at the definition of person aggrieved, it talks about an injury to a particularized interest. That subsection 3 for the property in the immediate neighborhood, it doesn't say that though. And you may ask yourselves, wait a minute, these people don't even have to show an interest. That's not correct though, because there's two components to standing in zoning appeals. The issue of standing in the case of a zoning appeal, as the Vermont Supreme Court says, in a 3-justice opinion, they pointed out it has two aspects. By statute, the litigant must meet the standard of an interested person. And that's that subsection 3, you're an interested person. And as a matter of justiciability, where's the tough word, by the way? Justiciability. The party must also have a sufficient stake in the issue which he seeks to raise. The fact that the litigant is an interested person gives him the right to pursue an appeal before the environmental division. It does not allow him to claim whatever he desires. Consistent with basic justiciability-ish requirements, he must still demonstrate a particularized injury. And the reason I point that out is because even though for that subsection 3, it doesn't say that that person needs to show a particularized injury, there are decisions from the environmental division which discuss that. And there is what we would call constitutional standing that the Vermont Supreme Court has talked about. And that even if the legislature says these people are interested parties and they can file the appeal, if they don't have a particularized injury, they have no standing and the case is dismissed. Then there's a number of cases that I have in motion decisions where the environmental division has done just that. Yes, you fit the criteria for this subsection 3. However, you're arguing a generalized grievance as opposed to particularized. What you're saying is that in the case I'm thinking of, it's called Bouffard. I believe the claim was that, well, there was a problem with notice to a number of other people. And the court said, no, wait a minute. The environmental division said, that's not your injury, that's a general injury. You don't have standing. Even though you might meet that criteria 3, you don't have standing. The environmental division issued a case called Capitol Plaza. And in that case, there's I think, a very nice discussion of these topics in terms of it leads you through, okay, how we have the standing. And what that case talked about was the provision under subsection 4 about 20 or more people getting together.
Right, where in the bill is that?
That is on page 34.
34, okay.
Yeah, start, subsection 3 is line 14, on subsection 4 is line 20. Line 20 it's called, it's now the group of 20, but it was at the time of Capitol Plaza, a group of 10. And what the court determined was that each of those 10 individuals had to have a particularized injury for constitutional standing. That it didn't just mean that 20 people, none of whom have a particularized injury that they can identify, can file. It meant that, yes, 20 can get together, even if they don't live in the immediate neighborhood, but each of them has to still identify a particularized injury. And the judge discussed how that works and the constitutional overlap of standing with the statutory definitions of interested person. And what he noted about the section 3, interested person, it says there, the statutory requirements of section 3 overlap with constitutional elements of standing. A person who owns property in the immediate neighborhood and alleges physical or environmental impacts to their interest, which are relevant to the applicable zoning criteria, will generally have the type of injury in fact required for standing. In a decision involving an interested person under subsection B3, the court has recognized that the statutory requirements for appeals of municipal decisions reflect the constitutional and prudential requirements of the standing doctrine. In other words, what the judge was saying is, even though it doesn't say particularized injury, when you look at subsection B3, if you have you're generally, for the most part, if you meet both of those criteria, you're going to have constitutional standing. You might not, as the judge has ruled in a different case, but the reason I point this out is because, again, right now, you have to have the particularized injury under the existing statutes and the existing interested person standard because of the constitutional standing protection. If you change, you're still going to have the requirement of that particularized injury to be alleged. But you will not have the restrictions of owner occupied in the immediate neighborhood, physical or environmental. And again, it would expand it. That is a policy decision. The courts will address it as it comes in after that, but I just don't want to see there be an expectation that by doing this, you're somehow tightening it, because that does not appear what would happen.
Yes. Okay, thank you for this, I'm trying to follow it. So this bill would narrow the number of people who are interested, but potentially expand the number of people who are aggrieved, or at least expand the reasons why somebody could be aggrieved.
It would not narrow the number of people who are interested, because it would be eliminating section 3 and section 4.
3 and 4, 3 and
Correct.
4.
So it would remove. I see what you're saying.
Yes, there are fewer people would be interested because 3 and 4 are removed.
Fewer people would be defined as interested parties under 3 and 4 because they would be gone.
Right,
In its place, what has happened is the people who otherwise would have been under 3 and 4 are now falling under the person aggrieved, which is broader
right,
than 3 and 4.
exactly. So there could be more people who are aggrieved, but we're not exactly sure because there has to be enough case law to figure out that extremely long list. I mean, if you look at that list of statutes, it's really complicated.
I think it's safe to say that there will be more people who, potentially more people who allege to be aggrieved,
Yeah.
who previously, they don't own property in the immediate neighborhood.
Mhm.
And we have cases, for instance, where the judges have decided, people who have filed saying, well, I live a mile away. And the courts have said, no, it's not close enough, you're not immediate neighborhood, or a half mile, that's not close enough when the court looks at it. And so that's going to be up to the court to decide how it works out. But when you take away that immediate neighborhood and physical or economic impact, you now have, again, somebody from the other side of town. I said economic, I meant environmental, who could allege economic, or they could start going through the list.
Yeah.
In 4302 and say, well, this is protected by this, diverse, this is educational, vocational training opportunities are affected. The question isn't whether or not they're going to be successful necessarily, but just expect that there's going to be more people who are going to be saying, we think we're aggrieved, and they're alleging that, and so the court would have to hold hearings and or address it for whether or not they are aggrieved under the statute.
So question about that, one of the things that has been interesting to me about the aggrieved person is that that's the standard for Act 250. And so there's a significant amount of case law, I assume, around how that has worked for Act 250. Does that, because this is potentially applying that standard to municipal appeals. So does that case law from the Act 250 world not get just carried over, or could be applied to the municipal appeals?
I can't tell you whether or not it would be carried over,
Okay.
because there would be a number of aspects of it. That would take statutory review and analysis. Well, you would have to go, let's say, you look at the definition, here's how the case law is. What were the factors that the court relied upon? Do those factors translate to the municipal zoning appeals, or are they standalone?
Right.
Or was Act 250, for what we looked at there, different? And so I can't give you an advisory opinion on that. Is it possible? Yes. Could it be persuasive? Could it find it? It really is something that the courts would have to determine.
Okay, thank you. If you look like you have more questions.
Yeah, I'm trying to figure out what I think about this. Do you know, I don't know if you can comment on this, but maybe you can. Do you know if this was an attempt at a compromise and, to say, well, we're gonna narrow this other thing, but we're gonna expand this other thing to try to come to a compromise, or what? Why was this What are they attempting to do here?
So my understanding is it came from the house and I don't know what their thinking was in the house about it, but there had been.
I don't know that either. But
Okay.
what I would say, what I think is safe to say is. The net effect is a broadening, because everyone who has property in the immediate vicinity, in the immediate neighborhood, and alleges a physical or environmental harm, would certainly fit within the aggrieved party
Yeah,
to
yeah.
allege that. So you're not, by eliminating three, you're not losing those people and somehow saying, oh, we're narrowing that. They're just going into a different category along with everybody else. And there's no more requirement of, again, environmental or physical or in the neighborhood, it's wide open.
Yeah. You can almost fit anything in this list.
One other question for you. One of the things that we had discussion around last year, with Act 181 was character of the area and being able to appeal on the grounds of that something doesn't fit the character there, but I think this is the case, but I just want to confirm that because character of the area is under D in this section 4302, that this
The reference is specifically to 4302C.
C,
It
right,
does
so
not
just, right,
incorporate D in that.
right, okay. You could not appeal on grounds of character for.
It's, yeah, again, the reference, as you point out, the reference is specifically to C. So that's the big picture item that I think has been discussed quite a bit. Happy to answer any questions. I did send a copy of the Capitol Plaza to the chair. If anyone wants it, the chair can get it. I think you may find it helpful to look at, because again, it explains that it's not just whether you say in the decision, oh, I'm sorry, whether you say in a statute, this party is an interested party, because there is something else. You can define someone as an interested party, but if they have no constitutional standing, no actual case in controversy, the case goes away. They can't pursue. So there are some other aspects of the draft that I would visit with you on, if that's okay.
Yes, that's great. So just for that's good.
On page 33, on lines 12 through 15, it says, except for cases the court considers of greater importance, appeals of an appropriate municipal panel decision under 24 VSA chapter 117 involving housing development take precedence on the docket over other cases and shall be assigned for hearing and trial or for argument accordingly. If you look just above that, section 4 is not an amendment because it was enacted last year. And that says that we'll try to, it is a goal to enter decisions within 90 days after the close of the hearing. The history of that is that there was a push to try to say, we want decisions by a certain time. There is case law from other jurisdictions, and I'm not giving an advisory opinion, that the determination of when to issue decisions is up to the court. And we control that. And it was noted, I pointed out to a panel last year in the committee that as the chief superior judge, I issued a policy that says under advisement cases have to be issued within 90 days unless there's exceptions or extensions. And that's kind of the outside. Are there times it might take longer? Yes. And the 90 days generally runs from the time of the hearing, or if the parties have time to file pleadings afterwards, that date, the latter of those two. But the 90 days, I was contacted and said, do you mind this, judge? And I said, well, if you say it's a goal and you say it's 90 days, we already do that. Do you need to put that in? No. If it's going to make people feel better, fine, put it in. But we already do that. So I didn't really worry about that too much because it was consistent with what we do. Right now, we prioritize every case. In other words, when a case comes in, the way it works is the environmental division, once an appeals filed, will then have a status conference. And that status conference, they'll discuss what the issues may be in terms of discovery, how much time do you need, when can you be ready for trial, things like that. Right now, I am told that if the parties came in today and said, Judge, we're ready for trial, we can be ready for trial right away. next few weeks, we can come in. That within the next 30 to 60 days, assuming it's a 1 or 2 day trial, the court can accommodate that. We do that. I'm unaware of cases that are waiting for trial, that the attorneys are saying, we're ready for trial, and the court just can't give us a date. Things are moving. Because when the court sets deadlines, it sets the deadlines based upon what our goals are as far as disposition, recognizing that we want to have the cases move. The issues that we're facing for housing, the court recognizes that, the environmental division, and I can assure you, the chief superior judge recognizes it with his discussions with the courts about, we need to make sure these cases move. The judges get that. And they try to move every case at the level that's going to work for the attorneys. There's not a whole lot of cases where the attorneys, as I understand it, are saying, Judge, we want less time. We want to move this. Generally, the attorneys come in, they agree on what the discovery schedule is, and the parties will then move forward on. I am aware recently of a case in the past several months where it was an on the record appeal. In other words, it was no trial. It was just the court has to take the record from the prior proceeding and review it, and then make a decision with input from the parties. And apparently the attorney said, well, we need 60 days for discovery. And the judge in the environmental division said, well, you don't need 60 days on the record appeal, but discovery. And so my understanding is the judge shortened that time. So judges do that. We understand. The idea that this bill brings with it is that we're going to prioritize these appeals of municipal panel decisions with housing over other cases. So if Senator Beck, St. Johnsbury, you have a project that's going to be coming in there, and you have a developer or a business that's going to bring 200 jobs to the Northeast Kingdom. And they come to you and say, I was in court, and the judge looked at me and said, that somebody's turning their seasonal camp into a single family dwelling, and they're getting a trial day instead of me. Because the legislature said that they have to prioritize it. Is that the impact that the legislature wants? If it is, this is the type of language that you might want to put in there. But I point that out because we already balance those things. What is more important? We don't say it like that, though. Could you imagine if I came out on the bench and said, well, we have 3 cases today. You're the most important case. You're second most important, and you're third. Anytime we start doing that, how does the person feel? Because the person who's in there for any case, I would hope it's the most important case to them at that moment. And we need to make them feel as though it is. And so this type of language where it says, except for cases the court considers of greater importance, that concerns me. Because I think the message it sends is that we're now saying your case is more important. If you get rid of that, appeals of municipal properties, it shall take precedence in the docket, that's a little different. But what I'm telling you is you don't need that. Because there's going to be that case where someone's going to come to you and say, I have this business and we need this. And I'm told that someone's duplex is taking precedence over 200 jobs. We can manage it without this language. And I think it works well. I'm unaware of issues of prioritization. I'm unaware of issues with scheduling right now that this would fix. So we then have on page 35, it's really further further discussion of what we were talking about before, where you remove 3 and 4. And I think that's about it for now. If you have any questions, absolutely at this moment, I'd love to answer them. If you have any in the future, let me know. You either see me walking down the hall or email me. I'd be happy to visit with you if you need any resources or information. My pleasure.
Thank you. One further question. So on page 35, this section C, purposes of an appeal of the act decision by an appropriate municipal panel. Interest person shall not include, okay, sorry, I just needed to tie it, so we're, because it's getting rid of 3.
Right.
Okay, thank you, I just wanted to process that really quickly. Thank you for your thoughts. This has been very helpful, and informative about how I'm thinking about this. Any other questions for, Judge Zuni at this point? Okay, if anything further comes up, we will be back in touch.
And again, it's your policy decisions. But,
It has impact.
and whatever policy you do, they have impact, but we will do what we need to do to have the timely administration of justice in our courts. So,
Thank you so much.
thank you very much. Have a great day.
Sure, you too. Okay, all right, so next we will hear from Mr. Groveman from the NRC. Welcome.
Thank you. Good to see you. Morning. Wish Hardy was here because I can answer some of the questions she asked, but I'll just start. So for the record, John Groveman, I'm the Policy and Water Program Director for Vermont Natural Resources Council. As background, I'm a lawyer as well. I've been involved in dozens of appeals, Act 250, A&R permits, and zoning appeals. I have direct experience. I've also was chair of my DRB for 20 years. Taking a break right now, but I'm sure I'll go back to it one day.
We all need a break.
You know, you guys keep us so busy. I have so much, and as I get older, like the curve of my energy and my age. You just grasp.
It's real.
So I did follow this bill very closely in the House, and so, you know, and I've watched those Judge only testify probably at least 5 times, maybe more, on the bill, and so there's not an agreement actually on what the language does. And I could explain how the House viewed it, and I agree with how the House, especially this language was developed in the House General and Housing, which Representative Mahali chairs, and he just happens to have been the dean of the Vermont Law School and is a very experienced lawyer. And so the issue started with, and this is a conversation we've had for a few years, and you all, I know that the chair will remember it, certainly Senator Bonner, but the standard for who could appeal a zoning permit, or best standing is the legal term, is different than, as you noted, Madam Chair, Act 15 and it's an odd set of standards that Tony went over. 20 people can petition, you know, they'd have to just sign the petition. If under the statute, they don't have to be injured, just get 20 people to sign. Live in the immediate neighborhood, as shows on you went through, you're a butter. I don't know why the legislature, you know, in the 70s created those standards, but they did. And over time, as Judge Zoney noted, so in 2004, when all environmental appeals were moved to the environmental court, and I'm talking about A&R appeals, A&R permit appeals, Act 250 permit appeals, and zoning permit appeals. Before they went to different places, there was an environmental board that heard Act 250 appeals, there was a water resources board that heard most of A&R appeals, and then the zoning appeals did go to Superior Court. It wasn't called the environmental court. But in 2004, when they consolidated all appeals in the court, the legislature created uniform standards for who could appeal. And that is this person agreed standard. And they did that because there was already case law for A&R appeals that's based on, and Judge Zoney alluded to this, constitutional standing. So under the United States Constitution, and this is the due process debate that is in the news everywhere on different matters, it's really the same concept. The United States Supreme Court has issued a number of decisions that kind of define due process for property rights, meaning if there's a decision by some sort of a permitting authority that could affect a neighboring property, if you have an injury that's specific to you, not a general concern. So like, take the Capitol Plaza project, which I know you know well, and I'll talk about that decision in a second. You can't just not like a parking garage. You can't like live in Middlesex and say, golly gee, I think that's a bad idea. You have to show that you would be personally injured in some way. So the US Supreme Court says if you can show that sort of personal effect and injury, and that injury could be addressed by the appellate court, and there's a dispute about whether you'll be injured or not, you have constitutional standing, but you have to prove what your injury is. And so in 2004, that was made the standard. This is the constitutional floor for due process for A&R and Act 250 permits. So if you appeal an A&R permit, you appeal a stormwater permit, and you follow your appeal with the environmental division, the permittee could say, hey, wait a minute, how are you hurt by this? You have to prove, you have to put evidence on, you have to either have affidavits or actually bring witnesses in, and you have to prove it. And every time, VNRC, we only appeal when there's an issue of statewide significance. For the record, we've never appealed a housing project, so I just wanna say that as I talk about VNRC's history with appeals. But I can tell you, it's not easy. We have to find people in the real world who have real injuries and are willing to go into court, which is a scary thing for many people, and testify and provide evidence of their injury. And I have seen, and so if we're ever going to appeal, we have to make sure that we have members who have that sort of injury. We have to prove it, and we have to make sure that they're willing to do that. So it's not easy, and it seems fair. And I think going back to what was the House thinking, the House was thinking, okay, if we have this standard for A&R permits and Act 250 permits, and it's based on the United States Constitution, it's sort of the floor of how property rights cuts both ways, right? There's property rights if you want a permit to engage in activity on your property, but there's also property rights for people who are actually affected or potentially could be affected by an activity to address those concerns. And so what the House said is, let's get rid of this, like you can sign, 20 people can sign a petition. Let's get rid of this, like what does it mean to be in the immediate neighborhood? Because that is not defined. What is, just let's say you have to have an injury. Let's go with the constitutional standing. And Representative Chair Mahali felt very strongly about this. He felt that this was, it made sense. And they didn't want to make many changes because in this bill, this is something that Judge Zoney didn't point to. There's a study on the appeal system that the legislature required last year in Act 181. And so they moved up the date of that study. So you'll see that in the bill. I am on that study committee. The next witness is on the study committee. We had a meeting on Monday. We have another meeting next Monday. And that group is going to recommend holistic changes to the appeal system that hopefully will create a fairer, more efficient appeal system for applicants that will address how we could prioritize housing projects and make sure that they don't get hung up in appeals, especially if they're affordable housing projects, but also create a system that's fair for people who do have legitimate injury and will result in good decisions that will be good for Vermont, because we'll have clear decisions and strong permitting programs and A&R Act 250 and local zoning. So I think, Chair Mahali's point of view is like, we don't want to make too many changes because we want to get that study. And that is really going to give us a more holistic set of recommendations. And we're going to be back here next year, and it is going to be exciting and it's going to be complicated because you're going to get a series of recommendations. I doubt there'll be complete consensus, but I think there'll be a lot to work on to really overhaul the appeal system in a really meaningful way. So what we're here now doing is what changes can we make now? Because we have a housing crisis, and you'll notice this is only about zoning, because if you look at the statistics, it's really zoning permits that sort of overlay more with housing appeals, more than Act 250, more than A&R permits. So the question of what can we do this year to sort of bring some consistency and clarity. And what the House chose was this making the person agree standard consistent across the board. Now, there's just a disagreement about what the capital plaza decision means. So I know this is a decision that probably haunts the chair and follows the chair wherever she goes. But so that decision is correct. I mean, Judge Zoney correctly went through what the decision says, but it was never appealed to the Vermont Supreme Court. And I think because the project ended up not going forward and there was no reason to challenge who could appeal, because there was no longer a project at the end of the day. But the lawyers differ, lawyers disagree and argue, I guess that's what we do, on one level. So I don't agree that that decision is correct. I think if it went to the Supreme Court, I think that the court read into the statute this requirement that not only do 20 people need to sign a petition, but you also have to be personally agree. That's not in the statute. I think that they have created a standard that is higher than the constitutional floor, that any person under the Constitution, as I went over, who could show an injury, could make an argument that is sort of a de facto constitutional standard, even though it's not in the statute. But I don't think it's legal to change that. You have to find 20 people, all with an injury. So even if you're potentially injured and your property rights are affected, and then you can't have due process, you have to go around town and find 19 other people. I don't think that's legal. I don't think that's consistent with the Constitution. I've talked with colleagues of mine, in particular, David Mears and Ron Shems, who have a law firm in town. Both have a lot of experience in environmental permitting. Ron sent a letter to Senate Economic Development, which I could share with you. And his legal theory is that Title 24 of the zoning statute actually incorporates the Administrative Procedure Act into it, which actually says that one person agreed now could appeal. And he said if he were arguing if there was a challenge to one of his clients about their right to appeal and they were legitimately injured, he would argue that under the APA, that's already the law. And all this to me says that this is very unclear, and what the legislature should do is bring a little clarity to it. So whether I'm right, or Judge Zone is right, or Ron is right, it's disputable. And let's get rid of the dispute. Let's write it into the statute. I think that the Learn Appeal group, and there was some business attorneys that are also part of that group that testified in Senate Economic Development. And my interpretation, you can have them in. Chris Roy is the person I'm referencing now. You should have Chris in. He's a lawyer for Democrat and Martin. What I heard him say is that he doesn't disagree that the person agrees standard is sort of the floor, but he wanted to wait on doing anything with appeals until we get the LERB study. But I didn't hear him object to that. I didn't hear him disagree generally with what I'm saying. And so from my point of view, and this was very important to the House, and you may want to hear from Rep Mahaly himself, because I am trying to paraphrase, and it's always dangerous what I'm doing, but I'm willing to take that risk, given where we are in the session and the confusion around this issue. But I think they're just saying, let's actually be clear, and there'll be less litigation and dispute around it if we make the standards consistent and uniform. We make it clear in the statute for zoning that it is the same standard as Act 50 and A&R. And I mean, Judge Zoney didn't say, to your excellent question, Madam Chair, that the Act 50 and A&R precedent wouldn't apply, but I am 100% confident it would apply. There is decades of that precedent. It's the same standard. You'd be doing the same thing, what I just described. You're a lawyer, you have to have a client who has an injury, and the injury would just be with regard to the zoning permit instead of the A&R permit, Act 50 permit, but it's the same process and it's the same standard. Now, the last thing that Judge Zoney said, which is something you should talk to your alleged counsel about, Ellen Bukowski, because the fact that the person agreed in the bill loops back to the goals of Title 24. It was Ellen's idea to add that, and I think it was the right thing to do. And you could have Ellen, and now I'm going to paraphrase what Ellen was saying. I'm really on the high wire this morning. And I think what Ellen was thinking is that we want to make sure that the injury is related to zoning issues, basically. That it's not related to, property dispute about an easement. It's not related to some other dispute that may be going on between neighbors. And it's sort of common sense, and you can argue that it's implied that if you're trying to appeal a zoning permit, that your injury needs to be related to the issues addressed by that permit. But Ellen felt it was important to basically specifically reference that. So there's no dispute that the injury in the case of the zoning appeal got related to the broad issues addressed by Title 24. And that's why it's so broad. That's why it's basically all Title 24, but it's not Title 10, it's not A&R issues, right? And it's not Act 50 issues, it has to be zoning issues. And so And I think that the way the Act 250 person review standard works is you have to be agreed by a decision under the Act 250 title, which is Title 10, Chapter 151, so that brings in all the Act 250 criteria. And for A&R, it says you have to be agreed by the decision under Title 10 that the A&R permit was issued under, which if that's the wastewater criteria, you have to be injured by that. It couldn't be somebody else or stormwater. But I think Ellen was just trying to make it consistent. And I hear Judge Zoney saying that the judges have to interpret that, but I don't really think there's much to interpret there, because I think it's just trying to stay within the four corners of the zoning statute. So that's, that's background on kind of how we got to where we are. I don't know what Senate Economic Development is going to do, but I think at in 10 minutes, they're taking this up again. And they have not been able to settle on what to do, in part because of the confusion around it and the disagreements and the different interpretations as represented by what you're hearing from Judge Zoney, and now what you're hearing from me, what you may hear from VLCT or anybody else. So it is a complicated area. It's not engineering, it's not science, there's law, and there are interpretations to be made and analysis of precedent to be made and opinions to be offered about all of that. But I had comfort in Chair Mahali kind of really honed in on this, and he is an expert, and I did agree sort of with his approach. The House committee, I think unanimously, it wasn't a compromise. They settled this sparse change to make while we're waiting for the appeal study from the Land Use Review Board. And it went through the House pretty easily. But we've had we've been having the same debate. Judge Zoney gave the same testimony in the House, and we've been having the same discussion in the Senate, and here we are towards the end of the session. So
Here we are.
so I hope that's helpful.
Yes.
I just, I at least gave you the kind of the range of the discussion and a little bit of background about how we got here.
Mhm. Thank you, and I assume you don't have any thoughts or comments on this last part, this prioritizing. I've lost it, where did it go?
Yeah, I really don't.
Okay.
I really feel that is within the purview of the court to decide, how it feels about the legislative branch. It is a little legally, it's interesting, like it's good, it's a fascinating separation of powers kind of discussion about the role of the legislative branch in directing the judicial branch, a separate branch, in terms of how it does its work. You certainly could direct the executive branch, you do that all the time, that's what statutes do, right? You tell the executive branch you have to do this, and you have to do that, or you shouldn't do that, or you can't do that. But when it comes to the judicial branch, it's a little trickier, so I really don't. I think, really, and more importantly, I think we all share the goal, and I can see, like, we had this meeting of this appeals group. I think everybody wants the appeal system to work better. And I'm glad that we're having the study, and glad Act 181 has that in there, because we had a 3-hour initial meeting on Monday, and it's complicated. And I think there are more than 30 people from every point of view. And that's what it takes, I think, to really make broad recommendations, to make real improvements. And still there'll be a lot of choices for you all to make. But this is just this one sliver of an issue, and you can see the challenges that are involved with it. But I think so, and I bring that up because in terms of prioritizing, I don't think it'll solve the problem. I think the problem will be more solved if we could agree on ways to make the system just work better generally. So
Questions? Okay, super, thank you so much. Yeah,
please, if you continue, something comes out of the committee, and I'm gonna go over there in
yeah.
10 minutes.
I'll be
and see
interested
what
to
they do.
see.
Yeah.
How it goes. Okay, and so we'll move on to Ms. Sheehan from VLCT, welcome.
Thank you. I'm sorry that wrapped up so suddenly. I was not queued up.
Oh, yeah, it's all good.
Hello, good morning. For the record, My name is Snre. I'm the municipal policy and advocacy specialist for the Vermont League of Cities and Towns. And I'm newly. You're very short.
Okay.
Um. So we have been chasing this very important housing bill around the building, certainly. The need for housing in tools for municipalities to enable the housing that Vermonters need and desire is at the top of the priority list for VLCT in this legislative session and biennium. As prior testimony has explained thoroughly, there does not seem to be broad consensus on the draft language and its impact. And that draft language seems very likely to change and is likely changing as we speak. So what I would like to do is avoid the bill language as much as possible. So as to not further confuse the situation or VLCT's position. I would or the interpretation of VLCT's position. I would like to instead hopefully make a clear argument for the outcome that we're looking for. Which is less appeals. Less appeals at the starting point is what VLCT has long been working towards over years. The reason is that we support efforts that enable the development of housing and public infrastructure that communities have envisioned, planned for, and left. Vermont state law in multiple titles and chapters requires a lot of local government in terms of public process in order to create local zoning and bylaws that guide what is legal to build in Vermont. Not guide, prescribe what is legal to build in Vermont. So I actually just borrowed this from testimony on your chamber's housing bill and Ways and Means yesterday, where this is also very much a discussion. So if we start with the municipal plan, state law tells municipalities, you have to have a plan, it has to have these 12 things in it, and this is the process that you have to undergo in order to write and adopt a municipal plan. That process is extensive, it begins at a citizen-led level with the appropriate citizen commissions within the town. Certainly the planning commission, but some communities have multiple planning commissions. They might have an energy committee, they might have a housing committee. They might have a natural resources committee, that plans components of the municipal plan. That is discussed by neighbors, debated, amended, put forward in an advisory form to the appropriate local legislative body, where that process continues there. Each proposed amendment requires its own notice period and public hearing. And then when the legislative body acts to adopt the municipal plan, there are statutory requirements for who must be notified and who the plan must be shared with. That starts with abutting neighboring municipalities, and that ends with the Department of Housing and Community Development. When we get into planning for growth, within designated areas in a municipality, that process starts all over again anew, separate from the municipal, in relationship to the municipal plan, but it's its own process. It is clearly defined and prescribed. It takes a long time and involves all of the same steps with an additional step at the end, which is a technical review by DHCD staff. And then in the designated areas have to be approved by a board formerly called the Downtown Development Board, now called the Community Investment Board. And then, of course, Act 181 sets different trees in different directions for the future of how our growth centers will be mapped, rules will be made, and how they will work in order to encourage the development of housing and mixed use buildings in the places where we most want to see those built. So this is to say that land use planning at the local level does not happen quickly, it does not happen in a vacuum, and it does not happen without robust public input. We feel that once the great majority of a community has engaged in this process, been heard, shaped it, written the bylaws themselves, and it has been adopted by local elected officials and through democratic process as prescribed by state law, that vision should be able to move forward with the construction of infrastructure, housing, mixed use and commercial development according to the plan and the bylaw of the town. Sort of without this, what is commonly called autocracy of a single party or a minority group, effectively ending progress towards that broad community goal. When we get into the creation of zoning and bylaw, this all happens much the same way. A bylaw could start with the legislative body of a town, it could start with a citizen commission. Ultimately, both need to inform the drafting of the bylaw. Every amendment needs a hearing, every amendment needs have a report posted, a public hearing and a 15-day notice period. In addition to what state law requires for the adoption or amendment of bylaw, many municipalities have their own local standard that goes above and beyond that. Many municipalities require 2 public hearings, for example. Some require a longer than 15-day notice period. Sorry, today's like my Friday, I'm running out of examples. Municipalities put themselves through a lot in order to develop broad public agreement and understanding of what the bylaw is. So VLCT favors deference to the local bylaw because of that consensus citizen driven process. I said I wasn't gonna talk about the language, but there's one point I want to make about the current draft 3.1 and what was passed, the official language that's passed by the House chamber in its housing bill. There has been a lot of discussion, as you heard this morning, about this aggrieved person, what constitutes an injury, where best to attach that to, like what chapter of state law or what area of municipal process. That is really good healthy debate, and I don't want to paraphrase or recount all of it. What has not been subject to that difference of perspective is the 20 persons. The removal of the standing for appeal by petition. There is much more agreement, and it has long been VLCT's position long before me and before the most recent changes to that provision in Act 181. That standing for an appeal by petition should be removed. We again think that this really interrupts at a late, high risk, expensive part of the process of building something. You know, this introduces an unfair opportunity for a minority of people in a community to end progress towards the broad, well-defined vision of the whole town and city. So we could support more than one option that is being discussed by our colleagues in the Economic Development Committee. We hope that the final option does remove this ability to appeal municipal zoning decisions by petition. We think that is sort of a straightforward way to get at our goal in the short term, to make short-term progress towards our goal to limit in a reasonable and fair way the overall number of appeals against municipal zoning bylaw. Oh, sorry, one other thing before questions, if there are any. There is another section which has gotten just so little attention. Which is section 18. This is a pretty significant change that would mean that if a municipality chooses, they could adopt changes to zoning in response to a new state preemption. So if the legislature passes a new preemption, then the municipality could choose one or two options. One, change zoning to be compliant with the preemption without the public hearing process that I described. Or two, go through the public process, which is sometimes a great option because they may want to reopen bigger questions around how to address the intent of that policy change, whether it's to have less cars on roads, to have more housing being built or whatever might come up in the future. Act 47 passed a number of pretty significant preemptions for municipal zoning, all aimed at promoting density in designated growth areas. Act 181 had more, just a few, and we heard a lot that towns were not doing it, or like we're not compliant. We're not hearing that from people, we're not hearing towns say that. Like we were not hearing obstinance from town officials, and that was a sort of confusing, so that was confusing. So we sought to understand that in our October member survey. We asked a number of questions about Act 47, Act 181, and the status of compliance within the 10-acre towns. And we basically found that the majority, 18 months out from the effective date, the majority of towns had adopted these changes through a local process and were compliant. The minority of towns that had not, were waiting for the RPC planner to come to their meeting so they could do it. And so that's sort of an unacceptable reason for the municipality to be non-compliant. And so potentially be causing confusion or conflict for people trying to build things. So we support it. We think it makes sense. It's really important to us though that it be optional, because there are a lot of benefits that we realize and support that come from local process.
Yes, go ahead.
So you had, how many 10-acre towns do you know?
I can never remember the number. Do you remember?
Not important.
It's roughly half.
So you got 254.
Yeah.
That's
240.
everybody weigh in on this survey?
So we had 80 responses to this, 88 maybe I think responses to the survey.
So you
Which is a
think
good, it's like a good sample.
non-responses of concurrence or typically or?
Yeah, I mean, yeah. Any other questions?
No.
Okay. Happy, once, once there's maybe something more clear and final to respond to, we're happy to be in touch individually outside of committee, come back if that is important. The question and the work being written up is really important, we care a lot about it. Just trying to not rock the boat unnecessarily.
Okay,
Thank you.
super, thank you so much. Okay, great.
Also, I've always wondered, okay. Every time I'm like, I'm gonna see what that says and then I forget.
I started to turn the other way.
Turn your, yeah.
That's it.
Okay. All right, so thank you. We're gonna switch gears at this point. We have Colonel Snre with us to talk about a different bill. So switching to talk about 230, but before we leave 479, thanks everybody for thinking about this. We'll see what economic development decides, and at least we are prepped if we take possession, they leave these sections in. Okay, so switching to 230. Some further changes to fish and wildlife rules. Welcome,
Thank you, ma'am.
whenever you're ready, go right ahead.
Appreciate it. So for the record, my name is Justin Stedman. I'm the director of the Warden Service. I thought I'd start, I understand from the discussion that happened yesterday, there was a specific question related to the increase in, or the request for the increase for big game fences. And that is mainly, it's twofold. One, they have not increased in a number of years. And two, when you look at other states, our big game penalties are considerably, some of the western states, you're talking $20,000 or $30,000 per animal. So our deterrence based on the fine is not really there, given the amount. And so that was the main reason for requesting the increase, was simply to try and get more and live with what others are doing. Yeah. And then I don't know, I'm happy to be generally, I don't know if there's specific questions, however I can be of most assistance to, maybe I'm happy to do. I don't want to go over a bunch of stuff if folks don't have questions. However, Madam Chair, you would like me to do it, I'm happy to do, or.
Well, I guess I have some questions about the section 6, reptiles and amphibians.
Yes.
Taking part. So this is new for Fish and Wildlife. Do you have a sense of with this, because you're on the enforcement end of things, do you have any concerns about enforcing something like section 6 about the taking of reptiles and amphibians?
So, and I appreciate the question. So specifically, I'll go big picture for a moment. So reptiles and amphibians are kind of the new frontier in North America for exploitable natural resources. One time it was big game animals, buffalo, deer, elk, moose, all this other stuff. But the illegal market in reptiles and amphibians has blown up. I was actually just listening to a podcast on the way here, and I was interested to hear that ants are becoming a significant part of the illegal trade. Wildlife trade. They were talking about one particular one from someplace in Northeast Africa. I don't remember the country, but a queen is worth $3,000 American. And so the point is if there's money behind it, people will exploit it. And so turtles, snakes, and other amphibians, mainly right now turtles, a lot of places where these creatures are used in sort of medicinal things, they extirpated their local species. And so they're looking for them in other places. And so we had a training a year or two ago. South Carolina was a specific place this kid could come, but they arrested two foreign nationals with over 500 animals, all pearls, snakes, and amphibians. And so the reason for this rule is that presently in Vermont, you cannot possess any live wild animals. So there is a protection from that. But beyond that, snakes and turtles and frogs have no protection. There is no limit, there is no anything really. And so the purpose behind this originally was to allow for the department to create rules to attempt to address some of this. And some of this is us trying to forecast what's happening. And the news that came about I believe it was a Chinese national trying to smuggle the turtles across the border. Like, we know that sort of stuff is happening. And I can tell you with very broad details, we have cases from Vermont that Vermont wardens have worked on with our federal partners where our local wildlife is or has gone to China, and we've been able to follow that. Unfortunately, we don't obviously have a whole lot of cooperation when it gets there, but it is what it is. So this is happening. It's not that it isn't. Admittedly, capacity wise, it's just one more thing, but I do really feel that it is an area where, as we are able and as this stuff comes up, we should address it. And right now, we really don't have the means to do that. So we had, I'm trying to remember, that we had one person that was caught, I think, with 14 or 18 snapping turtles. Those were alive, so we have, but if they're dead, there's nothing that prohibits that. And I am not an expert in any way, and I believe you're gonna hear from Luke, but one of the most impactful parts of the training we had was this graph that showed your deer, your bear, your moose, I think turkeys and turtles. And it was an age, and it started at year 1 and it went through year 17. And if you have, one pregnant or one adult at year 1, by the end of 17 years, you have something like 500 deer and 300 moose and 700 bear. You have one turtle. It's gonna take them 17 years to reach sexual maturity. So if you take 100 animals from a specific area, you could very easily and conceivably do irreparable harm to that ecosystem. And as we all know, I mean, we talk about ecosystem, but there's the microcosm of that and the individual wetlands and all that sort of stuff. So the point of 4085 was to give the department the ability to regulate this. The part that I would like to specifically speak to, at least from a law enforcement perspective, is that the House felt very strongly about putting the word intentionally in there, and intentionally significantly hamstrings us. There are very few places in Title 10 where the word intentionally appears. And Attorney Smith was able to dig up a Vermont State Supreme Court case, State v. Mobs from 1999, where the court specifically called out the fact that proving intent beyond a reasonable doubt is next to impossible. Which is why so few of our statutes or regulations speak at all to intent. One of the ones that was called out in testimony is 4702, which is spotting and locating. And it says you cannot intentionally cast a rays of a light. Well, if we didn't have it that way, every person that went around a corner near a field whose lights lit up a deer would be in violation. That's not, there's sort of a reasonableness piece to that. Additionally, there's only one statute that I can think of where intent is part of taking, and that is the one waste rule. Because it says you cannot intentionally take and then intentionally not attempt to recover. That's the only law that I can think of related to take where intent is specifically called out. And so we'll do what we can, but I'm just here to say that if it goes through intentionally, we're not going to be able to do a lot.
Okay, yeah, go ahead.
Thank you for that. This is interesting. I think the reason they put that in there, and I wasn't in the room, but what I've heard is because they were worried about somebody runs over a snake unintentionally on their lawnmower or hits a frog. Exactly, yeah.
You broke a law.
Exactly. So
We're not gonna answer.
I actually have video of me stopping and trying to save a turtle. Multiple times. I always stop for turtles, but I think it was to prevent somebody from, mistakenly hitting a frog, or turtle, they're littler than a deer.
They
You
are.
know, sometimes you don't know that they're in the.
100%, I
Yeah.
can't rob them, but here, that is a violation of law, so like, I really did feel bad, I didn't mean to, but.
You're
Like,
saying this on the record.
I am, I thought, where's that, I
What are you gonna do
when I
for
hit
yourself?
first, I'm funny myself, but no, so the point that I tried to make in the committee was just that, and the reason I said deer is because that's the most, you know, one of the
Yeah.
things, I mean, I think we had roughly 4,000 deer a year hit on.
Right.
But in Vermont, you cannot take any animal for which there is a season by anything other than gun, bow and arrow, or, you know, fire down sight. So if you know, every farmer that hits a deer mowing hay
Yeah,
is great, but that's not the point. And I didn't say this in committee, but 51 miles an hour in a 50-mile-an-hour zone is illegal. You don't get a ticket for driving 51 miles an hour in a 50-mile-an-hour zone. It's just not reasonable. And to some extent, that's where I think this lands, is a reasonableness piece, and we're not. First of all, I can assure you, we don't have the time to go stop every person that accidentally ran over a frog or a turtle, but. Putting intentional in here, I understand the purpose, I guess I'll say it this way. It tries to get at something that we're already doing, like, we're not, our mission is to aggressively pursue the intentional violator. We're not trying to get after the unintentional violator, and that's part of some of the other legislation that's coming before you, the dual track, which I don't want to get too far forward, but that's part of what we're trying to do, we're trying not to do this.
yeah, but I think that. I hear that, and if you take it that too far,
Mhm.
it's like. If you're using absolute discretion. Law enforcement just generally, you know, absolute discretion, then. That is not following the law. And so we don't want law enforcement to be like, well, there was that, you know, robbery that we're not gonna, you know, deal with, or that, you know, assault that we're not gonna deal with because we don't have time or whatever. So there is where's the line? And so I think that we, you know, we as lawmakers want y'all to follow the law, so, and enforce the law, so how do we? Isn't it better for us to draw that line in the law so that you don't have to?
So this is my response, again, going back to speed, you can accidentally speed, you cannot accidentally commit a burglary. And so that's where some of it comes from, I mean, I do it, you're just listening to the radio, the next thing you know, you're going 7 miles an hour, like I said, 1 mile an hour over the speed limit is breaking the law by the letter of the law.
I know, but I just feel like there's so much gray area, and I'm not necessarily defending the intentionally, I'm wondering if there's another way to get at what they were trying to accomplish and what you are talking about in the sort of on the ground.
Again, so there is no statute, there's, I think, 3 statutes or 4 statutes, but there's only 1 taking statute around in Fish and Wildlife law that lists intentionally in it. So you're talking about that whole book.
Yeah.
Nowhere in there is that word in it, and we're not running around willy-nilly making mountains out of molehills, basically is what I'm saying. At the same time, though, I have personally charged someone for running over turkeys with their car.
Yeah,
So.
there are people who do it intentionally.
Exactly, and that's
the thing.
the sort of the common sense approach that I'm trying to, and I don't say common sense to try and degrade what the committee was doing. But there has to be some common sense to this, otherwise the bad actors continue to be bad actors, and all someone has to say. If this law goes into effect and someone shoots a snapping turtle, all they have to say is, I didn't know what was there. I didn't need to.
I was just shooting into a pond.
It doesn't matter if you're shooting at, because the warden would have to put themselves where the person sat at the time they sat, to be able to say in a court, beyond a reasonable doubt, that there was no other possible target in line with where they.
Okay, so just to be clear, your argument is actually the intentionally makes it harder to enforce.
It makes it unenforceable.
And having nothing there and having the sort of vague of, you know, there are some things you're gonna enforce and some things you're not gonna enforce.
And it's not, yes, yes, you are correct, it sounds willy-nilly, but it's really not. The other thing, here's the other thing, there's checks and balances to everything, so a warden goes out and arrests me for running over a turtle. That case doesn't then just immediately go to the court, it has to go to a supervisor who has to approve it, then if the supervisor approves it, has to go to the state's attorney, who then has to, like, there's multiple checks to the process to say, no, this is not the right application for this. At the same time, with this here, like you. Not you specifically, but this language then negates that whole process, because as soon as this person said, I didn't mean to, that's it. We have no ability.
It makes me wonder about the issues with, hitting a bird with your car, or another example that I have chatted about with some colleagues is hitting a deer with your car. So my understanding, and please correct me if I'm wrong about this, but that taking a deer, well, I'm not sure if you call it taking, but if you hit a deer with your car, that could be construed as illegal.
Oh, it is.
Yeah. And there's a sort of intention, I guess what I'm saying is, I wonder if this issue of intentionality, or if there's like a reasonableness standard that could be developed in the future, that should apply to more things than just reptiles. Does that make sense? Like, maybe this is a bigger issue
Again,
that we need to address.
there's checks and balances though, because I assure you, there's no state's attorney that's going to take this case, and God forbid one did, the judge would laugh the warden out of the court. Like, it's just, because if you if you kill a deer illegally, you're going to the same court with murderers and drug dealers and everything else. So we're not sending cases where it's a laughable matter. And I mean, it's unfortunate, but like I said, roughly 4,000 deer get hit on our roadways every year. We're not, just no, I'm sorry, just that hard stop, no, we don't do that. And it's not, it's again, it's not. The funny part is that intentionally written into this gives an out, but not in it, that's what we apply as a metric. Like, did they intend to do this? Yes or no? If they intended to do this, at least if we believe they did, then we're going to prosecute, or we're going to send it for prosecution. If we don't believe they intended to do this, we're not gonna do it. And so,
Yeah.
yeah.
Another question.
So
Yeah.
you're talking about discretion of the officer and whatever, so, if you've got. Senator says, snap turtles kill more baby geese and waterfowl, and she says, I run over everyone I see. And then somebody actually sees her do it. And there are people. I mean, there's probably some.
Oh, that's right.
No, that's the thing.
Absolutely, so I think you're 100% right, Senator, and that is something that we rely on, and we've made numerous cases where people haven't utilized their vehicle to intentionally kill something, and if someone is a witness to that, and because there's 32, well, there's 42 of us total, like 32 out and about doing the job, for one of them to be behind it. Exactly, that's doing this sort of thing. But if someone witnesses it and gives a statement that says that they saw me swerve, we'll charge that.
Yeah.
You can't do that. And so that's where I know, I understand the logic of why it makes sense in here from sort of the point that I'm saying this is what we do. But if you put it in here, then like I say, it's the bad actors that then use that as the crutch to get away with everything. And it's the honest person who's like, yeah, I meant to, well, then they're gonna get hammers.
Is there anything in the rules that goes into this more specifically?
Not to my knowledge, no. And
No,
no,
but in the existing rules about deer or other animals.
no, like I said, the only taking statute or rule, the only rule or statute written in Title 10 that speaks to take is the wanton waste law.
Yeah.
There is no other place where intent is called out related to take.
No, but I mean, in the rules about enforcement,
Oh.
is there anything about discretion or intention or, kind of the gray area that we're talking about? No? Okay.
And I will offer for you that, I think this doesn't just apply to, this doesn't just apply to, I mean, if you think of any law that's written on the books that you can accidentally violate, there's a lot of them. I mean, obviously you can't accidentally break into somebody's house, but there are a whole lot of laws you can accidentally break that are environmental in nature or criminal, there's this sort of thing is applied across the board to the spectrum of titles that exist in Vermont.
Yes, but there are ways that is handled differently. I mean, it depends on the crime or the situation. It's all, that's specific.
Yes, that is very true, and the sort of the unwritten fact or rule is, like, we're not trying to make criminals out of people who don't need to be. That's the bottom line. Because it's not right.
And more questions on other sections.
Sorry.
Going, unless there's other, I agree. Is there any other questions about this section in particular?
No, I think, the fact that we don't use intentionally in other sections of statute and how people are taking. And there hasn't been an identified set of issues over time with it, leads me to think we should just take this word out and, because of, if we're gonna operationalize it, if we're gonna protect the incentive.
In the Supreme Court case I referenced, the judge, whoever wrote the, specifically called that out, to prove intent would be next to impossible in these cases, so.
Yeah, it's interesting that it's there, and it makes me wonder about, because I feel like it's probably pretty common that we've all been frog at some point, feel bad about it, and so it's like, oh gosh, well, I didn't intentionally do it, you know, so it's in there, but any case, I have some questions about other.
Yes, ma'am. Sorry.
No, thank you. So, just gonna find this section. Oh, you've got a draft.
I believe it's the draft 4.2.
Yes,
Okay.
okay, so, we've also had some, conversation about, it's in section 8, part E. And, I don't know if you have any comments about this. This may also be a question for Ms. Smith, who's here with us as well. There's a question around, whether section E is redundant relative to other parts of the law.
So, Ms. Attorney Smith and I spoke, because I don't know if you want me to speak to it or if you prefer to, whatever you.
We
Okay, so with the significant changes, because originally our language did not propose a ban on the harvesting of amphibians or reptiles, which is what now exists. This language was originally adopted to give us coverage for that. So it kind of was rendered moot. And it was somewhat redundant, but it was redundant for the purpose of trying to capture something that hadn't previously been captured, if that makes sense. So if you were to find to strike it, you would, I think, probably help, not hurt, certainly not hurt. In my opinion, I don't know if we want to add more, but.
Yeah, just for the record, Hannah Smith for the Department of Fish and Wildlife. And as the Colonel said, when we drafted the original, what is now section 6, it was discretionary rulemaking authority to regulate reptiles and amphibians. The version that passed out of the House, or the version that's being reviewed in the House now is a ban on taking. And then it also gives the department the ability to adopt rules that would further regulate, commercial use, any kind of open season, possession, etc. So when when it was drafted as discretionary rulemaking authority, this language in 4709 new E was seen as necessary to prevent basically the proliferation of any future commercial market for these reptiles and amphibians that we couldn't anticipate. With the language that prohibits the taking of reptiles and amphibians, this does become largely redundant because for the most part, you already in law, you cannot transport or possess a live wild animal. So I do think that it could be struck. And the other thing that Mike Covey raised yesterday was potentially an exemption for the sale of taxidermy. And I don't, it's not an unreasonable suggestion. I frankly don't know a lot about how large of a market there is for taxidermy, but it could be, I know there are people who buy and sell taxidermy in the state, and it would not be our intention to ban that. There are a lot of regulations that apply to possessing taxidermied animals. You have to have taken the animal legally to begin with. It can't be a restricted or threatened or endangered animal. So there are regulations that exist related to that market. And it was not our intention here to ban that. So I think that to the Colonel's point, it could be from the department's perspective, it could be struck. It's largely redundant if the protections for reptiles and amphibians are adopted into law. And that's all.
Okay, that's interesting, yes.
Thank you, that's helpful. Session 7 on the sliders. Slider turtle, pond sliders. I don't know if we already talked about this and I wasn't in it, but
A little bit,
Okay.
it was pretty quick.
can you just tell me why?
So I am not the expert, but and Luke will be able to speak to this much more definitive or expertly.
Yeah.
But pond sliders are one of the most common turtles in the pet trade,
Mhm.
and they are adaptable to our environment, and they are a threat in terms of pushing out native species.
Mhm.
And so that is my understanding of why that specific animal
Okay.
is called out. They've been identified as a problem in other states where they've established breeding populations and force out the native species.
Okay, so this would ban even pet stores from selling them after July 1st.
And if I'm recalling, Rep. Sakowitz, you mentioned that as people have these as pets, sometimes they let them go.
Yes.
Yeah,
Yeah.
Because then they.
longer than a kid is little and wants to.
Yeah, right, there you go.
And then unfortunately, they let them go and then they find each other and then before you know, it, we have a breeding population of
Yeah.
regular sliders.
Yeah.
That's not good.
Well,
for Yes, not good for our local species. So, and, oh, go ahead.
If
Sure.
I could add one thing, and I think Luke will speak to this, but this was one of the issues he was gonna talk about, and I think he's hopefully gonna be back tomorrow to talk to you guys. There is a concern around the date in this section, because it states, it creates a legacy clause that states that you can possess it if the turtle is legally acquired as a pet prior to July 1, 2025. There are licensed pet dealers in the state that may have these turtles in their possession that they legally acquired prior to 2025. And we don't want the pet dealers to release the turtles to avoid any kind of violation. So I think we were going to suggest maybe a slightly later date or some language that, I'm sorry, I don't have language to propose, but a later date to this can still apply to people who own legally acquired pets, but some sort of provision for pet dealers to ensure that they're not dumping them in order to avoid violating the law as of July 1. Apologize, that's sort of a half-baked proposal, but the language was introduced in the last version of the House bill and the wildlife staff flagged it as a concern that they wanted to raise for the.
Well, couldn't we just say something like legally acquired as a pet or pet for sale?
By a pet dealer, yeah, I think,
I keep the same date so that, even if the pet store hasn't sold the turtle by July 20th or something, they're not violating the law because they acquired it beforehand in order to. Oh, I guess then they could
couldn't
sell it. I
in
see
the
what you,
state,
yeah.
But I mean, to your point, we don't want them to sell it in the state after July 1, so I would. I could come up with something that maybe created a little bit of leeway, but I'm not sure. I think that it was a concern that this would be an impetus for people to further dump red sliders that are in the state.
Or how about, and this is hopefully this is not too insensitive of an example, but like when we created the plastic bag ban, we said we gave this time period for stores to get rid of their plastic bags. So that they wouldn't be in violation of the plastic bag ban to use up the bags they had in their stock room. And we could do something similar to that. I don't know exactly what the language would be, but
I think it's a good idea.
I
So
think
it's worth looking.
potentially even by the end of this year, if a pet dealer was in possession now, they would have, 7 months.
to,
in which they could sell turtles, or I don't know how they would return them.
Right.
I'm not sure.
yes, return, yeah, that's true, returning them apart, but like having this window where they could still sell them just to get rid of them.
If they have live
Instead of
turtles in their possession.
Releasing them into the pond.
Right.
Mhm. Okay, well, we'll flag that for now anyways, and something to potentially come back to. Any questions? Yeah. I think that was the end of the questions that I had.
I have a question.
Yes, please.
What animals are being pulled out of Vermont and sent over to Asia?
So up until originally it was parts of black bears. Really, and also there is already some movement of turtles. So
Live or
yeah, which is the only way they can come.
Blackbears is what's there.
Was that?
Isn't it the blackbears feet to the?
Yeah, so I'm not, so the warden that did most of the work on this educated me side, so it's something called bear paw soup. And what it aims to get is the meat that's in between the digits of the bear. And so that is some sort of either medicine or aphrodisiac, I'm not exactly sure, but and so there is a we've traced Vermont's black bears to two western states and China. So. Not just, I mean, with the help of us, as well as service obviously, or maybe not obviously, but not just us, I don't want to say that we do that.
And that's another very specific question, page 5, line 12. I think the phrasing is a little, I don't understand. Except for big game offenses and under revocation offenses, what are under revocation offenses?
So it's specifically one, it's trying to be a say 4280, I believe, which is hunting, fishing, or trafficking on revocation.
What is under revocation?
It's like a suspended license.
Oh,
So just like your
okay.
driver's license, there's a point system and everything for fish and wildlife offenses, and so a certain number of points equate to a suspension of a certain amount of time. Complicated, I'm happy to explain if you want,
No,
that's
that's okay.
basically what that applies to.
So if you do a violation when your license has been revoked.
Yes,
That is,
under?
yes, under, so if someone has lost their license and a warden catches them out fishing or out in the woods with a firearm or something like that, then they would most likely be charged with hunting, fishing, or trafficking while under revocation.
okay,
But that's the,
that was just an awkward phrase.
sorry, that's
No,
the way that, that's the whole
I'm
specific
not
one.
as familiar with it.
Absolutely, and
Thank you.
Title 10 is very nuanced, so no, that's a good observation, yeah. And part of that, the big game offenses piece, those are all things where there is no fixed fine, so it all has to be set by a judge, which is why those are exempted from this, they have to go before a judge.
Got it.
There's associations.
And associated judges.
I just have one other question about, on page 9, we talked a lot about section E and how it might be redundant. And I'm wondering if you could speak at all to F and G. Like, as of right now, are people that violate this section not subject to penalties in section 4518?
So 4518 is the big game offenses, which we talked about raising penalties for. So what this would do is this would potentially give us the ability to levy significant fines under the big game offense. The part related to G is something that was added because the environmental court, and I don't, and actually, please correct me if I go wrong here, because wardens don't operate within the environmental court, but parts of AR obviously do. And the environmental court can levy massive fines. They're civil, but they can levy massive fines. And giving the economic benefit to offenders with some of these species, it is quite possible that we would not be able to bring a high enough penalty to even offset the potential value of what they're going to gain. So the addition of the environmental court was brought up by Attorney Smith's predecessor as a potential option to be able to levy significant enough fines to offset the black market value of the animals.
Okay.
And I listen right away.
No, that's exact, I mean, the rest of 4709 is violations of the other provisions of 4709. With our standard fish and wildlife violations, so there's a criminal penalty associated with them, but as the colonel pointed out, it's not as substantial as the big game violations. And it, without this language, there would not be the option to pursue civil enforcement that could potentially require additional fines for mitigation costs.
And that is, the criminal side has no real compensation for his loss, so that is a significant area of gain as well.
Okay. Super interesting. I'm glad we're getting after this.
Yeah.
Okay, any other questions for the colonel or for Ms. Smith? Yeah.
Page 12. The public notice is accepting the threatened and endangered species.
Well,
Um,
happy to speak on that one, that's.
and just doing it multiple times, and there's obviously a logical reason, but.
Sure, so this section is, this is under the threatened and endangered species section of the law. And for certain the location of certain areas related to threatened and endangered species are confidential. So breeding grounds, essentially where anywhere that somebody might intentionally pursue and prey on them illegally. That's largely confidential. Our natural heritage inventory will identify quadrants where there is a teeny species, but it won't actually identify what the species is to protect those breeding grounds, for example. Occasionally though, so in the regulatory proceeding, there's an exemption from that confidential location when somebody owns the property, or a consultant might be in a data sharing agreement with us where we can let them know what's there in order to protect the species essentially. And so they're in the regulatory process like Act 250 or 248, it's really important for the landowners to know what the TNE species is there so that they can get an appropriate permit and avoid impacting. In some of those proceedings, the location of these species comes out because those documents that are reviewed might be public. So this adds additional confidentiality protections for location of TNE species that are being reviewed during a regulatory
Species,
threatening
technical. Oh, teeny.
T and E, sorry.
Oh, I thought you were saying teeny.
Very, very tiny. Very tiny.
That's so funny.
So this would allow us to, the department would have to develop a specific list. So that's what on line 5, page 12, we would have to develop a list where the location, and it could be like bat hibernacula is one, like bat breeding, threatened and endangered bat breeding grounds are very sensitive. We would develop a list of specific species whose locations would remain confidential even in those regulatory proceedings.
Okay. Okay. And you would keep it under lock and key so nobody would know where those locations are.
It would
That's
not
the problem
be-
with data security and things like that.
For example, the location would not be part of the information that was put on public notice.
Okay,
So
so the list would not have their locations, be like, oh, here's where these bats are.
No, it would just be a list of the species.
Okay, of the teeny species.
Of the heat tank.
Alright, thank you.
It's a martini.
I know, there was like some plant, this little tiny plant, and that's what I thought you were referring to, that they just discovered.
That's certainly one thing.
Yeah.
Nice. Any other questions? All right, well, thank you so much, really appreciate it.
Thank you.
Okay, so we'll move to Mr. Fidel, welcome.
Thank you.
Morning,
Good morning.
I'm Jason Fidel, I'm the Forest and Wildlife Program Director, and General Counsel at Vermont Natural Resources Council. Thanks for having me in. It's the first time I'm testifying in their committee this year, so appreciate the invitation.
And you've met everyone, you know. I can meet you.
Sorry, waiting. So at a high level, we strongly support this bill. Some of the work that's in this bill was the result of group that got together over the fall and winter. There was these are not new versions of legislation. Some of these were provisions last year. They got some attention. Representative Sacklowitz had some proposals to focus a little bit more broadly on our recovery process for threatened and endangered species and looking at different policies to try and improve the recovery of those species. We've been really interested in that idea and the policies around that. Actually, when I went to Vermont Law School, that was sort of my thesis, was how do we look at programs and policies to help the recovery of species in Vermont. And so we had some fruitful discussions. I think we recognize that there's more work to do to figure out, you know, there's capacity issues. There's really looking under the hood of the available opportunities we have to work with partners across the state and figure out how to improve. There's over 200 species that are listed that need recovery attention. A handful of those species do have plans, but many don't. And so that's an issue that we're really interested in, but there was a number of policies that came out of the discussions that really made sense to move forward this year. And those are what's in, you know, this bill, and we looked at 231 as well. So we appreciate that the department had some discussions that, you know, related to teeing up the bill. And you know, as I mentioned, really the area that I've been focused on based on sort of my expertise has been the threatened and endangered species provisions in here. So just wanted to, you know, underscore the importance of the sections that relate to doing more to protect and conserve reptiles and amphibians. There has been a gap in our laws, and this is an important improvement, and they are species that do need conservation attention. And so we definitely support these provisions in the bill. You know, also the sections that relate to prohibiting the take and collection and possession of these species unless authorized by rules. So we support the fact that the department will have the authority then to do some rulemaking in order to make any important clarifications and allow for it to take under the appropriate circumstances. Also support, you know, the provisions that we would be able to do a better job of protecting the identity of species if they're going through a permitting process. You know, we don't want to allow people to easily connect the dots if they're trying to permitting, you know, process and then be able to figure out how they can go take a threatened or endangered species. So that makes a lot of sense. As I was tracking the conversations, I haven't had time to talk to the Fish and Wildlife Department about this, but I did talk to Representative Sacklowitz. I had some similar concerns about the term intentionally. I know at the federal level, you know, there's been discussions about how if you require, you have to prove intent, that oftentimes that can be very difficult, can allow for, and oftentimes, you know, sort of the deliberate take of a species, but somebody has a pretty good reason for why they didn't intend to take that species. And so I haven't thought of all the examples of how this could apply to reptiles or amphibians, but I understand, you know, the policy intent behind what the House was trying to do. That we don't want to signal to people that if you accidentally take a species under a number of circumstances, that there's going to be enforcement. So, you know, if there's enforcement discretion, I guess, or if they're going to address this so that we. Anyway, I'm flagging this. I think there's merit to looking at that word and deciding whether, you know, it could come out and then there's not going to be enforcement under, you know, scenarios where people legitimately didn't intend to take the species. So I don't know if this can be clarified through the rulemaking itself. If there's a, you know, but anyway, I'm flagging a similar concern about this.
and how it could actually weaken the ability to protect reptiles and amphibians. I do want to also mention that this doesn't really relate necessarily to the bill, but you may be aware that at the federal level right now, there is a proposed rule that would actually remove harm from the definition of take under the Federal Endangered Species Act. That's a really serious potential challenge to the protection of threatened and endangered species. Because the way that that's been interpreted is that relates to destruction of habitat. And so if you destroy the breeding grounds of a threatened or endangered species, it's going to be very hard for that species to survive. And there's a lot of circumstances under which habitat modification, that has been the principal way in which take permits are analyzed and issued at the federal level. I'm flagging this just because I think it's going to be important over the summer. You know, hopefully this bill, you can move the bill and we can get some important provisions in here, because we don't want species to be moving towards the threatened and endangered species list, either in the state or at the federal level. So any actions we can take here to keep, you know, common species from being listed serves everybody in the long run. Serves landowners who house these species, right? To applicants who are going through development projects that don't want to have to deal with these, you know, potential takeover species. So any work we can do in the state to help species from being listed is really important. And then once they're listed, then we have a lot of this conservation work to do. And so over the summer, we're really interested in understanding, are there going to be gaps that are left from some of these federal changes? Is there anything more we should be doing at the state level? Can we figure out some policies to recommend to you all about how we can do potentially a more comprehensive job moving species off of the list, right? So that they're not there and have regulatory impacts. So I'm just teaming up that we have a white paper that we're working on that I'm glad to share with you that will be available this summer, and it'll outline a number of different ideas. And so just appreciate, you know, your consideration, attention to these issues. We'd love to continue having a discussion with you potentially next year. You know, once some ideas are generated, we have time to share them with the Fish and Wildlife Department and other interested stakeholders. So with that, I think that's all I had.
Super. Any questions for Mr. Keenan? All right. Thank you so much.
Thank you.
Okay. All right, so we, our next topic is scheduled for 11. Where we're headed is a discussion about where the judiciary, committee, landed on salts. Actually, before we do this, any other comments or thoughts on 230 that we just that we just went through? Just so folks know, my inclination is to include 230 in general into 231. It all seems relevant, though. Actually, let's talk about this. The changes that folks might want to see in 230 as it goes into 231. And I mean, some of the things that we talked about include this word intentionally, about taking of amphibians. Another thing that we should talk about is whether or not we want to take out section E, as it may be redundant. Oh, sorry.
Are you looking at 230?
Sorry, page 9.
The 230.
Looking at 230. 230, yeah. So looking at possibly including the bulk of 230 into 231.
And 230, has it been passed by the House yet?
It's not passed by the House. So we could wait to see how that goes.
Yeah.
So my thought is either we include this in 231 or we wait and let it travel just across the biennium. I am open to either. My instinct is like, well, if it seems like it's relatively not controversial, if we can move it forward, then I'm game to do that.
But do you know why it was sent back to the committee? Because it was supposed to be on the floor, I think, on Tuesday morning's house. Do you know why?
I don't know
why.
Um,
Was it because of controversy or because it was?
I can find that out, I don't know. So. If it's because of controversy, then we probably shouldn't do it.
Exactly.
But if it was because, the conversation was, oh, well, the Senate's going to include this, then, well, that's a difference, so.
Yeah, but I think I told you that I
Yeah,
had
if you had thought it
information
was that.
that
was going
morning
to.
from a reliable source,
Yeah.
that it was gonna be on the floor that morning.
So I'll find out why
Okay,
230 went back. And if it was because of controversy, we'll wait. Does that sound okay to everybody? If that is not the case, and the reason was just, it's coming here and there's a different vehicle, we don't need to do it in the house. In general, without getting into some of the specific things that I've flagged, how do you folks feel about including 230 into 251?
In general, I don't see a problem with it, as long as you see the finished product.
Sure. Understood.
For sure.
Yeah.
Yeah.
Those two changes.
Yeah.
I think there might be key changes that,
Yeah.
intentionally, and the pet dealer situation
Yeah.
related to providers. And then the paragraph B, removing that,
Yeah, yeah,
Selection.
yeah, same.
the plastic bag, that was like.
Yeah, so we take out intentionally. Though I do want to flag that for some further conversation, if there is. It would be more comfortable to me if there was language somewhere that was, some kind of language around reasonableness, in thinking about whether something was intentionally taken. I don't think we can solve that right now, but for some future conversation, do you have thoughts on that?
Yeah, my inclination would be leave it alone because it doesn't seem to be an issue.
Okay, it's not solving a problem.
It's not solving the problem. If there is one, we can solve it.
Okay.
Yeah.
Fair enough. And Ms. Smith, if you have suggestions around the pond slider, language,
Hopefully send those to you today.
okay, that would be amazing.
And find out what would help them.
Okay, that would be great. And then taking out section E. On page 9 about that may be potentially redundant. So that all sounds good to everybody?
Yes.
Okay. Great. Okay. So we'll plan to do that. I'll let Michael Grady know for our next draft. Super. Thank you.
Thank you very much, appreciate it.
Okay, so sure, yes, a break would be fabulous, thank you. Yeah, Okay, so this is Senate Natural Resources and Energy coming back from a break. And, oh, we have Michael O'Grady, amazing.
That's like, fuck.
That was phenomenal. So we are switching gears, to talk about the salt bill. But actually, before we do, since I did get some answers to the previous question, 230 was not sent back, to committee. The chloride bill was sent back, but 230 is on the floor today. So, I'm writing you an email right now about some changes for that we discussed in terms of 230 going into 230. So it's almost exactly 230, but it'll be an email. Okay, but we are switching to talk about salt. We have all the people, this is amazing, oh my gosh, delightful. Okay, so, we hear that there has been, some agreement, and so grateful for that. So we're gonna start with Senator Hashim, to tell us about how that went, then we'll go to Mr. O'Grady, to walk us through, some language, which thank you for putting together. Welcome.
Hi, thank you for having me. I don't think I've sat in a witness chair yet, let's say. Nader Hashim, Senator from Windham County, Chair of the Senate Judiciary. We were tasked with talking about salt a lot this session. Appreciate that. And yeah, we focused on the liability piece in the bill. I know there was debate as to whether or not there should be limited liability and affirmative defense, or if there should just be nothing in there. I understand the stick and carrot approach in different bills. What we landed on eventually was the affirmative defense approach, which is a carrot, though it's a smaller carrot than the limited liability approach. I think the biggest point that made me comfortable moving forward with that, and I think, and the majority of the committee moving forward with the affirmative defense approach, is that the two folks, Adam and Jared, who are on different sides of the conversation, came to an agreement that the affirmative defense approach is a solid compromise. And please correct me if I'm wrong, I don't want to misconstrue anything, but that's what it sounded like yesterday. And yeah, that's the gist of it.
So I'm gonna have more questions about what affirmative defense means and how that is legally different, or why it's a smaller carrot, so to speak. I could ask you that. I can also ask any number of the other folks here too as well. Yeah.
Yeah, I'll do my best. The civil law isn't my area of practice, it's criminal law, but I can still, it's still some crossover, but an affirmative defense is something that is raised in the defendant's response when they get a complaint. And it's also something that can be incorporated into jury instructions. And it is, if you meet the elements of a affirmative defense, you can move for summary judgment earlier on, so you don't necessarily have to wait until you get to a jury or to a trial. And when you meet the elements of affirmative defense, it can negate the culpability and the amount of liability and the damages that can be imposed. It can negate it in part or in whole. And so that is, and using this approach is, in my opinion, a more balanced way to go about it, because it doesn't quite as easily shut the door for a plaintiff who may have been injured in an incident. But it does still provide more clarity in law as to what can be potentially put in jury instructions, or what can be raised as an affirmative defense at the very beginning of the case. And that's, yeah, I would say that's the gist of it.
Great. Okay, super.
Yeah.
Thank you. Any other questions for Senator Hashim? Thank you for taking this up. Thank you for your time and your committee.
Yeah.
So grateful, and Yeah, so glad we're able to have you all land on.
Yeah, absolutely, and I'm confident that Michael Grady can correct any errors I made regarding perimeter defenses, but that's where we land.
Okay,
Yeah,
super.
thank you.
Okay, Mr. Grady, welcome.
Stick around and watch.
So do you all have a draft that's labeled draft number 2, 1.1?
Yeah.
Yeah.
Yes.
And because you had a draft that came out of here that was reviewed by Senate Judiciary. So this is basically what I understood to be the discussion yesterday, and basically conforming your original proposal with provisions in H 86 in the House with the language about a permanent intent, the affirmative defense. So nobody actually asked me to do this. I just did it. So if there's something that is not consistent with the intent of the Judiciary Committee or your committee, please tell me. So with that said, I'll just step through the highlighting, which are the differences between your original proposal and this proposal. So there's a purpose and intent section. It's the purpose of the act to establish the accepted standards of care for application of salt and salt alternatives in an effective and efficient manner to provide safe conditions to pedestrians and motor vehicles for travel and services while also reducing the effects of salt and salt alternatives and quality of the water. That was something that was discussed in the House. I think it is something that is helpful in this version of the bill with regard to the affirmative defense, and I will address that in a minute. Then on page 1, section 2, you have the establishment at the Agency of Natural Resources under the water quality law of the fluoride contamination program. All of the definitions are the same. So I will review those. Then you come to the creation of the program. A&R still creates the program. One line or one word that is not highlighted, which should be, it's on page 2, line 20. The House was very clear that this is a voluntary program, a voluntary education, training, and certification program. And so this version also includes voluntary. And on page 3, lines 4 through 6. Both bills, the S-29 as it came out here in H86 as debated and discussed in the House, had the establishment of best management practices. Your version gave the agency a choice if they wanted to do those BMPs by procedure or by rule. The House wanted it by rule because it provides additional clarity for advocates and interested persons because the public participation requirements under the APA for rulemaking are more vigorous than what they would be for procedure setting. So this requires adoption of the BMP by rule under the APA to allow for public participation of interested parties. The actual substance of the BMPs is the same in S-29 as it came out of your committee and in H-86 as debated in the House. So at the bottom of page 4 in line 18, subsection C, this is just an additional kind of massage of the language to reflect that it's a voluntary program. So the program shall offer training for commercial applicators to be certified. So it is not a mandatory program. It's designated as voluntary in the creation of the program, and then the program offers the training to applicators not required. On page 5, line 9 through 13, your version had a significant reporting requirement or a reporting requirement for state, commercial, and certified applicators about the amount of soft they use, and then A&R was going to do a report on the amount of soft used. This has been consolidated down. It's the commercial salt applicator submits an annual summary of total winter salt usage. And then A&R establishes methods to estimate and track the amount of salt applied by certified commercial salt applicator. So this is a substantive difference between what you proposed and what is in each 86. Moving on from there, page 6. Now you get to the section that used to be the limitation on liability, but is now the affirmative defense. And I think Senator Hashinji a really good summary of what an affirmative defense is or can be. The term affirmative defense isn't used in civil liability law in our Vermont statute, but the dynamic, the mechanism is. And Senator Hardy referenced it yesterday, or maybe the day before this, they're all blurry together. About how in healthcare law, there are provisions that say if there is alleged malpractice by the healthcare professional, and the healthcare professional can show these criteria, the healthcare professional will not be held liable for the harm that was caused. It's a very similar instance here. Remember, you had an S29 and in H86 that limited liability protection is like a plaintiff basically is not prohibited from bringing in a negligence claim, but it's restrained from bringing that negligent claim because you give that salt applicator liability protection if they are certified, they're applying according to the BMPs, the alleged harm is from snow or ice, and the fact that the snow or ice wasn't removed was because compliance with the BMPs. That makes it the plaintiff's burden to show that the liability protection does not apply. It effectively changes the standard that a plaintiff has to show in order to go forward with their claim. So they either show that the liability protection doesn't apply, or they show that the standards of gross negligence or reckless disregard are met. So it's the plaintiff's burden. And there were concerns from the advocates that that is limiting a remedy or dissuading a remedy, and for those persons who are injured, and there was concerns about that, I'll just say. So this shifts the standard. Instead of it being the plaintiff that has to show that the limited liability doesn't apply, it's now the defendant, the commercial salt applicator, that has to show, just like the healthcare professional, that they are not going to be liable because they met the standard of care. They were certified, they were applying BMPs, the damage was from snow or ice, and the fact that it wasn't removed with BMPs. It is similar to current standards of care, which goes current standard for negligence claim, which goes back to the first section of the bill. The purpose of the bill is to establish the standard of care for commercial salt application for purposes of, so this is allowing that negligence claim. The plaintiff can still bring the negligence claim. The plaintiff doesn't have the burden of showing anything other than the components of negligence, duty of care, failure to follow, damage. But the the defendant can negate that potential liability, as Senator Hashim said, and relieve themselves from liability by showing that they met the criteria for the affirmative defense. They met the standard of care for commercial salt application. And that's basically what this does.
And the criteria for the affirmative defense includes, you just mentioned them, I think, duty of care.
It's very, very similar to what you looked at for the liability protection, but the burden is now shifted. So let's look at this section line by line. Page 6, line 4, a commercial cell applicator or their owner, occupant, or lessee of real property maintained by the certified applicator shall have an affirmative defense against a claim for damages resulting from a hazard caused by snow or ice. If the claim damages were caused solely by snow or ice, and any failure or delay in removing or mitigating the hazard as a result of the applicator's implementation of the BMPs. So they show that the plaintiff says, I was harmed, you had a duty of care that you failed to comply with, and you were liable to me. Now the defendant says, no, I was following, I'm certified, I was following the BMPs, the damages were caused solely by snow or ice, and the fact that any failure or delay in removing the hazard was a result of me following the BMPs. So litigation will occur, but this provides additional protection to the commercial salt applicator. The burden is going to be on the applicator to show the defect. And that defense does not apply to damages caused by gross negligence or reckless disregard. If you are having someone that is totally disregarding the standard of care, acting in a reckless way, you're not going to give them an affirmative defense. And just with the limited liability, in order to maintain or assert the affirmative defense, you have to keep the records of your snow keeping, of your winter de-icing, of your maintenance, and you have to retain them for 3 years, because 3 years is the statute of limitations for tort claims. So that's the big change. One of the big changes for your, so that's the big change for purposes of the Senate judiciary.
Yes. I think you should have asked Senator Hashim myself, apologies, but. Did they take any testimony after they came to this compromise? From anybody who. I'm concerned that this will be not a significant carrot for people to go through all of the hassle of the training and all of that. And that we will set up a program that nobody will take advantage of. So I'm wondering if.
I am not aware of any, but that doesn't mean.
Okay, I'm just wondering if snowplow drivers are still gonna do this, if this would feel like enough protection for them to go through and then do the record keeping and all the things that we're asking them to do. Because it sounds like if the burden is still on, because right now under current law, if they're without this law, without any of this.
The plaintiff has to show negligence and the defendant has to show that they met the standard of care and that they are not liable.
So this is not that different than current law.
It's not that different, except it's when you meet the criteria of an affirmative, is even if you were engaged in the conduct alleged, you generally are released from liability, or as Senator Hashim said, that they might reduce your liability, not totally release you, but you're generally released from it.
Okay,
Just like that healthcare professional.
right. But this is just a little bit lower. Rush.
It's more affirmative, at least the way.
Can't use a word to define it.
Sure, and it applies standard of care.
Right. Because right now there is no no state standard of care for commercial application, there's no. As far as I know, industry standard that isn't disputed or disputable. And now you would be setting a standard for these commercial salt applicators as certified.
Okay, that's fair. So like under current law, there's nothing that salt applicators can point to every day, like I was following these practices. And so this makes it easier for them to be like, look, there are these.
That again
rules.
is a reason to include that section 1 and what is the purpose of it.
Yeah.
Should I move on?
Well, I have one other question, about. A sub 2, any failure or delay in removing or mitigating a hazard. As a result of implementing the best management practices. So,
And that's very consistent with what your language was.
okay. Okay, great.
Yeah, basically like if they don't plow immediately because best practices say. To review a waste then. Right? That's not.
Yes.
Okay.
Okay.
So there are additional differences
Mhm.
between this language and S29 as it came out of your committee.
Yes, let's keep going.
So the House had an education and outreach requirement that A&R as part of the program is going to provide outreach to commercial salt applicators. About it needs to mark it out by page 8, line 5 said liability protection, it should say something else. And then they're also going to provide education for members of the public who are using salt and salt alternatives on their impervious surfaces regarding the potential harm of water quality for some wildlife and the excessive application that would decrease potential harm. So that was just, there was a question about whether or not there should be more education or outreach about these programs and the harm of fluoride applications that I thought that was relatively harmless to include olive branch to the house.
Yeah, no, we talked about that too, we just never came up with language.
Mhm.
On page 8, line 11, this is a significant difference between your proposal and what Senate Judiciary discussed and what the House has proposed. You had a requirement for cover for covering salt storage by the state, municipality, and private. And you had dates for cover if the facility was within 100 yards of a water or groundwater drinking water source or outside of 100 yards from a drinking water source. The House moved away from that requirement largely because A&R asked them to. A&R was not comfortable, especially with enforcing a cover requirement on private. They don't know where they are. They don't believe that they have the ability to determine where they are. And they would rather have a summary of the issue before they go to a mandated cover requirement. So in place of the mandated cover, there is the requirement that A&R do an inventory of the storage of salt and sand mixtures and sand at state and municipal facilities. So it's not about private facilities anymore. It's not a mandated cover. And they will inventory the facilities, they'll estimate the number of facilities that are currently covered, they'll estimate the number that are not covered and within 100 yards of a drinking water source, those that are more than 100 yards with a surface water drinking water source, and then estimate the total cost to cover or move facilities for storage, including proposed annual amount that will be required to meet the timelines for cover and management. So this also addresses your transportation committee's concern about whether or not municipalities would receive assistance for cover. But it is a big change from what you had, because you had cover. And this is not a mandate cover. Cover is.
But it's what the House wanted,
Yes, well, it's what A and R wanted.
what I don't know. Just add my, why wouldn't you cover your salt? Yeah.
Then moving on, section 4, remember the municipal salt applicators, when they conduct or do the training under the Vermont local roads curriculum, they got limited liability. They will get the affirmative defense. Underneath this proposal, there's also discussion about whether or not to give the municipal applicators any relief. And I, for sake of being magnanimous, included them. But again, I wasn't directed to do any of this, I just started putting this language together for your just.
I'm glad you did.
So the affirmative defense provisions are basically all the same. If they go through the local roads curriculum training every 365 days, they have the affirmative defense. Actually, 300.
Can I ask you a question?
Yes.
Michael, on page 9, actually,
Yeah.
on line 11 and 12, shouldn't you reverse the secretaries? Because the Vermont Local Roads curriculum is the Agency of Transportation's curriculum.
It is, but A&R does provide, they do make changes to the local roads curriculum.
Oh, they do?
Yeah, when you did like the local roads, the municipal roads, stormwater permit. Or the roads and bridge stormwater requirements, A&R was the one that proposed the changes to the local roads.
Okay,
But I just followed the models that I used in that.
got it, okay.
Thanks.
In page 11, section 5, the fee report. The House Ways and Means Committee was very concerned that there might be a third-party vendor, and the third-party vendor might charge commercial applicators for certification. And they wanted to be very clear that any fee that was going to be charged either by the state or third-party vendor would have to be approved by the general secretary. So that's why that highlighted. It's highlighted. And then. So. Ongoing concern about the money, Senator Baruch referenced that they are trying to limit the positions. This would create a position. He asked how A&R would feel if there wasn't a position for the program. I think they were pretty clear that they needed a position. I said as much. And so that's an ongoing question for you within your appropriations committees.
Yeah, so I had a conversation with Charles Martin from A&R about this question of like, if we move forward with this program, they want it to be sufficiently funded, and if there isn't funding, can they not do it? And so that's just to be clear, so as this is drafted right now,
This is drafted, it will create a position, it will give them money, and it will be outside the appropriations process. Which is not, the end of the world. It's been done before, but it's not. It's not JFO's preferred method or your appropriations.
right. Good, yeah,
It's not in the budget at all,
it was not in the budget, it was too
too much else to hear.
slippy, yeah. So. Just thinking through possibilities here, we could, delay implementation to next year and say, you know, hopefully put in the money for this in next year's budget. My understanding is that they're, you know, if we delayed it to next year, then it may even appear in the governor's recommendation, so it's a possibility.
We could also leave it in as it is and just include language that says. If funds in a position are appropriated, then department shall not be required to.
Yeah.
The program or something like that.
That may be the simplest thing to do, and then hopefully it can be on the radar for next year for funding.
The result's the same though,
It is right,
practically.
but if we take it out, then it doesn't ever go to it doesn't ever go to appropriations.
No, it'll go to appropriations. Well, I guess it depends on the vehicle. And how the language is. If it goes as S-29, it'll go to appropriations, because the
Right.
S-29, if it goes in another vehicle without the money. Then. It may not have to go to appropriations depending on the vehicle.
You know, it reminds me of how we framed things for H 41 about the Clean Water Board. It was directed them to recommend money and because you can't find a future legislature, but you can we could recommend that future legislature put money towards this. Then I wonder if that would go towards, make it go to appropriations.
It would.
Yeah. Well, I mean, my inclination, I think, is to go with just a clause like. If there's no appropriation, then A&R doesn't have to do it, but I'm open to discussion about that.
I mean, do you think you're on appropriations, do you think there's no chance in hell if they're gonna give this bill the position and the money?
I think at this point, no, I mean, we were even looking, the positions that are in there, I think are at risk because they're responding to the criticism that there are too many positions in there, so.
Well, if you, as chair and member of appropriations, think there's no chance that this money and position are gonna get in there, then I think the just taking it out, putting in.
Effective date.
An effective date of each year or.
Yeah.
You know, then
Mm-hmm.
at least we have the program in statute and
Mm-hmm.
we'll get.
Yeah.
Funded next year,
Yeah.
then it will save a trip to appropriations.
Yeah,
If we're
make it
putting this in the
shorter.
miscellaneous bill, is there anything else in there that has an appropriations?
I didn't think so. I think it will have to go to finance.
Yeah.
Yeah, but
This will make you go to finance too, it's about you.
yes. But I was looking at that, whether or not we go to appropriations otherwise, and there's nothing that I found. I could be wrong still, but.
Secretary Bloomer is. Sometimes. Mysterious about why it's here.
So, any other thoughts on how to approach the money part?
Bring that the governor be vote to accept the bill. Without. Language that. Just discussed about the possibility of saying it doesn't, the whole bill doesn't become. Operational, or does take effect until there's an appropriation, like. Better. Better number. By the way, for what it's worth, I think this notion of having the General Assembly. Approve a fee. Sounds awesome, back up in middle of page 11, but I guess we do fees all the time.
They are, you are supposed to.
Yeah, okay,
That's our
all
job,
right, okay,
first cover of it.
yeah,
And the House, because of the constitutional provision that says all revenue. Provisions, although it doesn't really apply the way the House thinks it applies.
So actually, Senator Beckerson and Williams, do you have any thoughts on this?
On the report.
Well, on whether or not to just have a delayed future start date or to say that the program doesn't have to run unless it's funded. If not, that's okay. Just want to make sure that you have thoughts, that we
Can't run a program without funding.
yeah.
No. So I just say push up.
Mhm.
Those are the good things I like about the bill, economic. So.
Oh, no, wait, well, first,
Well, I thought, makes sense if you're gonna cover and try to move salt sheds, if they're in, particularly to within 300 feet of
mhm.
floodplain, and then. We're counting on general contractors to fund the program as well as to go through the hoops of registering, and then they've lost their relief from liability, so
I don't think they would have to fund it, what do you mean by that?
well, their fees and everything are going to help to fund it.
Oh, well, like to pay for the rate relief.
So
I think that was originally there,
Do
yeah, that's not.
Well, it's good to know where you're at. We do have a couple other folks that would love to hear from. And if you have any thoughts on this question, that would be welcome. Thank you so much, Michael. And we can go in either order. Sure, go ahead. Welcome. Yeah, that's.
Good morning, Adam Crassi, the Crassi Group, from our Association for Justice, bringing support to this provision that I will kind of explain briefly. For this committee, the work of trying to go after non-point source pollution is important. It's took 100 years to mess up our waters, and it's going to take a long time to work on non-point source pollution. So well intended. That, as you engage this legislation initiated, is the kind of tension between salt and the environment. When we go into the heart of the bill on the liability and accountability matters, it brings in a different tension, say intersection in this bill, which is safety versus corporate premises management practices. And so as this bill, which second only to the education reform bill, has made more appearances in this year. So this is the notable mention for most engaged bill. And I think we've testified in the judiciary committees 9 times in the House and Senate, which is good because you're trying to craft step forward in codifying tort law, which is Vermont among the 50 states does the least of any. And so at the intersection of safety and corporate premises management practice, think about the Home Depot parking lot, where we come. And let me just put it in plain language. We're the folks who are thinking about the Vermonter who gets harmed by failure of due care on corporate premises to make it safe. And those injuries caused by that breach of duty result in serious damages, think lost work for a wage and hour person or serious handicap that happens. And so when you bring that lens to this legislation, it started to tighten up and find, how can we have this four corners serve the environmental need while maintaining access to justice for those who are harmed by the corporate failure to create safe premises. So what's good about this bill for business is that it brings in the clarity of what the standard of care is. Right now, tort law, duty, breach, causation, damages is for business unclear. What is my reasonable duty? What's reasonable care? Creating the best management practices is a way to define what reasonable care is, and then to give it legal significance through the affirmative defense is a step into make the business environment for the salt applicator more clear and safer for them. So we find this to be balanced. Think of an affirmative defense in the sense as lightly stated. You're guilty, you hurt somebody, and because it was dangerous premises that, and they got really hurt, well, you're excused. Because you did the best you could do by following these rules. And, so with that, you know, in the Judiciary Committee, we spent a lot of time talking about tort law. For you all to know, Vermont has the strictest jury standard in the country. We're one of a handful of states that still have that. It's why going, you know, when you look back over 50 years of legislation coming out of here, we don't do a lot of wading into tort law. Because you have this jury, these common sense juries, a plaintiff has to convince 12 jurors that they met the standard of care. Not 10 out of 12, not 6, 12. A handful of states have that. What that means is that the salt applicator only has to convince one juror to say no, and the plaintiff's case fails. So there's a massive natural downforce that we have in Vermont through the nature of how we left the tort law almost as it came over here hundreds of years ago. It's the common law. It's the most frequently occurring regulation of interaction between business and vulnerable people that exists. You can't write laws for every interaction between a business and an individual. You have to count on common sense and people buy insurance for if their worker does a bad job and turns their car in front of an oncoming vehicle, that there's insurance to take care of folks. But do know that Vermont's tort regime is really in its pure sense the common law. This bill codifies a piece of the common law, the affirmative defense, that provides business clarity. It's a good step forward. The win for business is the best management practices getting created, and that's unlocked by creating this. Whether you can get to the full incentive for how that person in Walmart is hand applying salt all the way up to their boss saying check a box, and for the absentee corporate premises owners liability insurance regime, it's a circuitous route we're here to embrace, taking a step forward on that. But do know there's great skepticism along the edge of sketch to connect those two dots. With that, thank you very much.
Thank you. Any questions for Mr. Lewis? I want to go back to something that you said about convincing 12 jurors versus convincing one juror. So one of the differences between the common law and what an affirmative defense would require is that?
No,
Oh,
that
okay.
will remain
Oh, okay.
the standard in this bill.
Okay.
This bill changes nothing about the plaintiff having to convince 12 people.
Gotcha, okay.
I mean, this is like saying the House Committee. All 11 of you and your assistant, any one of you say no,
Mhm.
the bill dies,
Mhm.
the petition stops. And so the standard is pretty high right now, and you can't, there's no jackpot justice, there's no, you know, litigation in America is a controversial topic, it tends not to be fair.
Mhm. Mhm.
This is why, I wanted you to have the why.
Yeah,
Okay,
right. Thank you very much. Hey, Mr. Carpenter.
so you're much more. Yes.
Good morning, Jared Carpenter, Lake Champlain Place, maybe good to see you all again. No, we thought it was a better idea for Adam to go first, because he was just gonna talk
Sure.
narrowly about the liability provision, where I wanted to talk about that, but also more broadly about the bill. I spent some time yesterday afternoon, I was thankful that I didn't have to do it. Taking notes on H86 of what the differences between 86 and 29, but now they're sort of combined together. I'll start a little broadly, so. CS 29 was passed out of this committee, wound up in Senate Judiciary. Essentially, House Environment picked up H86, which was the mirror image of 29 as introduced. But they put in S 29 into that as a strike call and then started making changes from there. And House Judiciary made some changes as well that Michael suggested, like the purpose and intent and things of that nature, changing it from guidance to just rulemaking, which is a good idea all the way around. Is the bill 100% of what the environmental advocates wanted when we came in here? No, but it's good 75%. Yes, we would have liked things to, we were advocating for the coverage of the salt storage. And we'll continue to do that, but understand that, you know, the study language gives the opportunity to get a sense of. What's the issue? How broad is it? You know, what are we talking about? How many storage sheds? What's the cost gonna be? Where can we identify funding sources to help towns? The study is due January of next year, so it gives the opportunity to come back and revisit that conversation within this biennium. If you all recall, I wanted more extensive monitoring language, the advocates that asked for that, and it's and more efforts to establish a baseline of knowing how much salt is being used right now. So we knew how much it was being reduced, we knew the progress we were being made. That language was reduced down at the request of the Agency of Natural Resources, but I think it still starts that conversation of finding a baseline. So overall, I think the bill has landed in a good spot. You know, we like the idea of H86 as it is. It's currently sitting on House Environment's wall. But then I'm okay with the liability language that Senate Judiciary came up with yesterday and told them so as well. It was is it as big of a carrot? No, but it's not like one of those little teeny tiny baby carrots either. It's, I mean, I think you've got sort of you know, we'll have to see. I mean, is it enough? There wasn't any testimony taken over there.
It's a full bag of baby carrots.
That you buy like the 5 pounds and it's I think it's a good start, and I think as this progresses forward, we'll have to look in on that. I mean, are we seeing the number of signups for commercial applicators that we wanted to see initially, or are we not making enough of a dent in salt reduction? I think that's something that this committee can look into in 2 or 3 years, and we can drag all of us back in and say, okay, you set up the BMPs, we've got the program running, how's it going? You know, this is oversight should be a part of.
There's still salt and water.
Yes. So, I mean, all in all, I think the bill has landed in a comfortable spot. In terms of the conversation about pushing the dates back a year or saying if the program can't start until it's funded, I prefer the latter, as Senator Bongart's mentioned. It gets it out there. It gets it in the books. It very specifically says that this is not an unfunded mandate. We need to give you some money in order to stand it up. I'm not sure what ANR's preference would be. But I know they have spent some time, you know, highlighting the amount of times that this body has done programs for the Agency of Natural Resources, but not provided enough funding or enough staff to carry them out. We all know, have heard about that. So I think that would make the point that this body is serious about the program, wants to start as soon as possible, but understands that the money needs to come either in the BAA or next year's budget, be it hopefully staff positions. I think that will be necessary, especially with the education program that was included in here. We need somebody to do the education and outreach as well as the certification program. Stand up. So all in all, yeah, it would be helpful to see the salt storage study done this summer regardless. It doesn't seem like it's a lot of lifting, but it's an A&R question, that's not gonna be a question. Because then when you come back next year, we can have that conversation about you know, funding and coverage of salt sheds and things of that nature. So it's a delay, but I think we'll still get where we want to go ultimately.
It sounds like we'll be more informed when we take that step.
I mean, how many sheds are we talking about? What kind of cost, and overall, is it gonna be, you know, $1 million, probably more than $10 million? It's just, there isn't a basis for that, and taking out the private. We would like to see the private salt storage included, but we understand where A&R is coming from. It's just, you know, 3 guys in a small pile of salt with a tarp over it, and there's just no way of knowing exactly how many are out there. And I guess that that issue with the rest of the future as well.
And just to be clear, so your preference would be to say something to the effect of like, A&R does not need to carry out this program unless it is funded.
Correct. And I guess with the dates, we probably have to come back with a miscellaneous and buff things out a little bit, but you know, fingers crossed, they can start thinking about it at least when we get somebody in the BAA, and they can start it, maybe not immediately, but they can start sending it towards the end, you know, midway through this budget cycle.
Okay, great. Any questions for Mr. Clark?
Great, I want to keep us within the lunchtime hours.
All right, super. Well, thank you so much.